Part of my responsibility as a member of the board was to help to guide the board into its new directions. At the time, I think I was the only judge. We did not then have, let's see, I was sort of the legal voice for them. We had a number of lawyers who were active with JACL, but not any judges. Then two persons, Henry Miyatake and Shosuke Sasaki, came up with this then strange idea about redress. Henry Miyatake, who is still alive, was an engineer at Boeing. Shosuke Sasaki, not now alive, was a retired editor for one of the major publishing houses in New York. And they had this idea to develop a plan to ask the government to provide redress for persons who were affected by the incarceration experience. And I can't remember the sequence of the years, but either around that time or prior to that time, the case of Gordon Hirabayashi came before Judge Donald Voorhees in the United States District Court for the Western District in Seattle. And what was called one of the series of coram nobis cases. Judge Voorhees determined that 9066 was based upon a false premise, that the government knew that the information was false and there was no basis for incarcerating citizens of Japanese ancestry in 1942. And that case was appealed by Gordon Hirabayashi's lawyers and by the federal government. And they went to the United States Court of Appeals for the Ninth Circuit. And that court not only affirmed Judge Voorhees' decision, but also set aside Gordon Hirabayashi's conviction. And Judge Voorhees had decided not to set it aside because the United States Supreme Court had 32 years earlier upheld the conviction. But the Court of Appeals case reversed it entirely, so Gordon's record theoretically was wiped clear. And it was around that time that redress was being discussed. Henry Miyatake and Shosuke Sasaki would meet with me here in my house, in this very house, in this very corner. And from time to time we would meet and discuss the plan and the idea. And here was an engineer, an editorialist, and me sitting on the side telling them what I thought. And so this went on, and finally it was presented to the Seattle chapter of the Japanese American Citizens League. It had a rough time in the local chapter. The president of the chapter then was Cherry Kinoshita. And she got aboard and was very enthusiastic about the idea. Ron Mamiya, now a municipal court judge, I can't remember whether Ron was on the court at the time, but Ron was designated as the chairperson of the local committee. And so in the chapter itself, there were discussions and debates over whether it was a good idea and whether it made sense and whether it would ever be accomplished. And it was taken to the National Japanese American Citizens League, and it was an explosive issue at the national level. And Ron Mamiya, who was our local representative to the national JACL to present the redress concept. Ended up being asked to resign from that activity by the national group. But the Seattle people kept pushing it and kept pushing it and kept pushing it to the point at which it became an acceptable issue before the national JACL. I never attended national meetings except one that was held in Seattle. But at any rate, Henry Miyatake and Shosaku Sasaki kept pushing it and kept pushing it at the local level. Ultimately, it reached the point that it came before, well, before that, the government established the Commission on Relocation and Internment of Citizens. It was a 20-person commission that conducted hearings around the country and issued a report in 1982. And that report determined that 120,313 persons had been wrongly incarcerated in relocation centers or prison camps. And that was the foundation for redress, was the report from the commission.